All right, welcome back, ladies and gentlemen. I do apologize for getting you back in here. Appreciate your continued patience. Mr. Claypool, anytime you're ready, the floor is yours.
Good afternoon, ladies and gentlemen. I'll try to make this as quick as possible. Let me start with the first row. Does anybody in the first row watch any local television from November 28th, which is the Monday after Thanksgiving, up until the time you were called in for jury? Did any of you watch any of the locals? Showing no hands. Row 2, from the Monday after Thanksgiving up until the day that you arrived here for jury duty, did any of you watch any of the locals? At your 2.1 Miss Sun? Hi. Right. What local stations do you typically watch? ABC? Any other local stations that you typically watch? Is that enough? Oh, okay. Anybody else in row 2 that had watched any local television from the 28th to Monday after Thanksgiving up until being called for jury duty? Anybody in row 1 or 2 have read any of the local newspapers from the 28th of November up until the first day of jury selection? Showing no hands. Moving to row 3. Let me ask the question first, Mr. Jones. Row 3. Has anybody either watched local television or read local newspapers from Monday, November 28th, the Monday after Thanksgiving, up until you arrived here for jury duty? Mr. Jones, you said yes. What stations do you typically watch?
CBS football games.
You ever watch any other local station?
No.
You only watch football?
On local, yes.
Have you ever watched the news on local?
No.
Moving along, row 3. Mr. Jones, have you read any local newspapers?
No.
Row 3 is Miss Guerra.
It was discussed the other day, not the only answer.
Anybody else in row 3 is Miss Botcher? So what local stations do you generally watch? I'm sorry? 12 and 25. And do you ever read the local newspaper? Okay. All right. So do you get email from the Palm Beach Post?
Just the headline.
The headlines, and have you been receiving any of the headlines from the Monday? I'm sorry?
I've been receiving them for years.
Right. Okay, and then I apologize if I interrupt you. Just to be clear, have you received any of those alerts from November 28th up until jury? Okay. Thank you. Anybody else in row 3? We covered row 3. Row 4. Anybody in row 4 who, okay, moving to 4.3, is it Ms. Chapnick?
Yes.
Oh wait, 4.2, Ms. How do you pronounce, I'm sorry.
Funk.
Ms. Funk. Had you watched any local?
My local meeting syndicated.
Tell me what you watched. Yeah, that's fine.
No, we don't want anything.
What about local?
Clarify that.
The local, I'm referring to local, I'm not sure.
The NBC, CBS, those no.
Right. Read in local newspapers?
No,
Huh?
we don't.
Okay, all right, moving on to, is it for Ms. Chapman? Yeah.
Like I told you before, we wanted that to be considered under the morning at TV on, and there was a case saying that they were seeking the jury.
And just so everybody feels like I'm not repeating myself, I'm not trying to repeat everything you've already told me. I'm just trying to find out what your general habit was from the Monday after Thanksgiving, which is the 28th of November, up until the time of jury selection, whether you may have watched any type of local television channels during that time or read the local newspapers. Okay, so that's my general question. And Ms. Chapman, before I leave you, do you typically watch local channels? I'm not even talking
No,
about.
actually, my daughter had it on that morning, and I just put it while I was getting ready.
Okay, moving on to row 4. Anybody else? Why don't you tell your name, ma'am, again? Sorry.
This is everything.
Okay, Ms. Patterson, 4.6, thank you. Okay.
But I watch local channels, but I don't watch the news. I watch it through on demand. Because I have certain sitcoms and stuff I watch, and when I get home, I can go straight to on demand to catch up on my program.
Do you ever watch the news?
I check the weather, and that's on my phone.
All right, you read the newspapers at all?
I don't get pictures.
Okay, anybody else in row 4? Is it Miss Muniz? All right. Okay, all right. And do you typically, though, putting aside my timetable of November 28th till now, do you typically watch local news here?
I watch football most of the time.
Okay, anybody else in row 4? Ms. Reed?
Yes, we discussed part of it before, but I do watch the news since I've been called to come into jury duty. The minute it even comes on and they say a D, I turn it off and leave the room. And I don't know the stations, but I watch 3, 9, and 10 on my TV, whatever they are. And I Comcast.
Thank you very much for sharing that with us. I think we're in row 5. So again, question, row 5, anybody from November 28th, so that's a Monday after Thanksgiving, up until jury duty, had anybody watched any of the local news channels? Ms. Prince, okay, thank you.
I can't say I really watched it, just in how because they were listening on the I'm sorry, I had to
Did you say that, can you repeat that again a little bit louder, please?
I know nothing about the case.
Okay.
Didn't know that it's just like that.
Okay. All right, thank you. Anybody else in row 5? Dr. Barsky?
Yeah, sometimes the news is on at night. There's no preferential channel, whether it's ABC or CBS or NBC.
But do you customarily watch what locals channels do you customarily watch?
Whatever news is on, I don't think we have a specific channel. So whatever we were watching to roll into the news, we usually just don't change it.
But you do watch local news in Palm Beach?
If it's on, I'll watch it.
All right. Does your wife watch it?
Yes.
All right. So if your wife has it on, would you be watching it?
Yes.
All right, thank you. All right, row 6. Anybody row 6 who may have watched any of the local news channels from November 28th up until the first day of jury selection? Seeing no hands, row 7. Same question, Mr. Zatrada?
Yes.
Yeah, tell me which stations you might have watched.
12 and 25.
I'm sorry, 12?
12 and 25.
12 and 25? Okay, thank you. And anybody else in row 7? It's Ms. Drozdowski. Right, tell me what local stations you would typically watch.
25.
25? And you may have seen channel 25 during the November 28th time period through. Yes? Thank you. Anybody else in row 7? Oh,
It's
Ms.
really, it's Good Morning America, and they come in little things,
They come in with the local hits? Right, okay. Thank you. And then Ms. Kennedy, or I'm sorry, not Ms. Mr. It's been a long day. Sorry.
I skim the
With no
Post.
coffee during the coffee break, or during the
I
lunch
skim the
break.
Palm Beach Post almost every day.
You read the Palm Beach Post almost every day?
So it would have been that Monday and Tuesday, but nothing after that.
All right, so you would have read the Palm Beach Post Monday and Tuesday. How about any local television?
No.
No, okay. All right, anybody else wrote 7? Seeing no hands, Mr. Martinez.
No, just
No.
stay with me.
Okay. Mr. Singh, just had a question for you. Mr. Williams had asked you a question yesterday about the believability of police officers. Do you remember that, just generally, that discussion? I think you had given a percentage of 80-20. Do you remember that? Is that yes? Did you say that you believe police officers 80% of the time? Yeah, did you say yesterday that you believe police officers 80% of the time and disbelieve them about 20% of the time?
No, that was the question.
Okay, what was the question? I
The
apologize.
question was the percentage of good cops and bad cops.
Oh, okay, thank you. All right, so you believe 80% of the time there are good cops and 20% of the time there will be bad cops. So if in this case I'm trying to tell you or convince you by evidence that we have bad cops, I've got to get over an 80% hurdle. Is that fair?
I wouldn't say that's accurate. No,
Okay. Pardon me?
I wouldn't say that's accurate.
Okay. Well, would I have a tougher hurdle to prove to you that these police officers, in this case, if I'm able to prove it by evidence, are not telling the truth, if you have a belief that 80% of the time police officers are trustworthy?
No,
Okay, where's Mr. Hornsby? Mr. Hornsby, I believe you had said that you believe police officers about 95% of the time?
I believe that's correct.
All right, so do you think it might be a little hard for you then in this case if part of my job is to show evidence that the police officers in this case were not trustworthy, it would require me to meet a pretty significant burden in your mind?
No, I'd listen to the evidence, and they very well may be the 5%. I'd base it solely on the evidence.
Let me move to, thank you, sir, row one again. Is there anybody in row one that believes that police officers are more believable, generally speaking, more than 50% of the time? As a general rule. Mr. Melcher, you're not to pick on you, but it looks like you're thinking about it. What do you feel about that?
Well, I was just thinking about how, I guess there's more responsibility, but, that's why I said so, I guess, once you see him as a person, mostly, everyone's doing that, so I guess it is right around 65. I was just contemplating.
Okay. Is there, just to make this go faster for the entire remaining panel, is there anybody here that, before we start trial, believes that other than who I've spoken to, who believe that police officers are more than 50% believable? Mr. Mark, Mr. Jeff, the question.
Approach.
Does anybody out here believe that there are more good cops than bad cops out there? Okay, Mr. Martinez?
That's correct, sir.
You believe that?
Absolutely.
Okay, thank you, sir. Let's see, row 2, 3, 4, row 5, and is it Mr. Douglas? Is it? Oh, row 4, okay. Mr. Douglas, I got that right. Okay, so you believe that there are more good cops than bad? Pardon me? Okay, great, thank you. All right. All right, then in row 4, maybe your name again? believe that there are more good cops than bad
Yeah,
cops?
I think for about 5 years, we've been working on
All right, let's go to row 5. Who in row 5 believes there are more good cops than bad cops? To make it go faster, your name now?
it. Shirley.
Okay, and you believe there are more good cops than bad cops? All right, great. And Pam, your name? I'm sorry?
Carol Logan.
Okay, you believe there are more good cops than bad cops?
Yes.
Yes, okay. What's your next? I'm sorry?
There's more good human beings than bad human beings. Absolutely.
All right, and ma'am, your name?
Evelyn?
Okay, and you believe there are more good police officers than bad police officers? Is that yes? Anybody else? Row 7? 6, I'm sorry.
It was Francis. There's more good officers.
All right, great, thank you. Your name?
With a,
Okay, and you believe there are more good police officers than bad police
Yes.
officers? And by saying good police officers, you would all, never mind, I'll withdraw that question. Next, ma'am, next juror. Okay, go ahead.
Annette Walker.
You believe there's more good police officers than bad police officers? Thank you. Ma'am, your name?
I would hope so.
You believe that there are more good police officers than bad police officers? Is that yes?
Yes.
I'm sorry, I'm having trouble here.
Yes, I hope so.
Thank you. Okay. All right, anybody else in the back in row 7? Okay. Your name, sir?
Mr. Moore,
And you believe
there are more good cops than there are
All
bad
right,
cops.
all right, thank you. I wanted to talk to a few of you who have mentioned that you might have a hardship. You've already discussed that with His Honor. But I just wanted to follow up with a few of you to make sure you'd be able to focus and concentrate on the evidence in this case. Where is Mr. Hang on a second. Miss Sun? What was your hardship again that you mentioned? English is not your first language. Do you have any trouble once in a while understanding me?
Yeah.
That's what we need to know. Thank you. Thank you, ma'am. Mr. Jones? I think you indicated you had some issue with your back.
Back in the, yes, sir.
Back and neck. Again, I'm not picking on you, not trying to make it personally. We're just trying to make sure you'll be able to focus during the case. Do you think that during the trial it might be difficult for you at times to be able to stay focused on the evidence given some of the pain you're experiencing?
No, sir. I'm in sales, and I'm able to do that every day as a living, getting up and down and pay attention to it.
Okay, that's great. Do you have, and I apologize if you were asked this, do you have to take any medication?
I'm wearing a machine right now.
Okay. But you're not having to take any medication that would make you drowsy?
No.
Okay, great. Thank you for that. And where is Miss Nunez? Hi. And can you tell me again what was your hardship?
My hardship was based on appointments that I have. I have a live active contract that is due to close on or before December 30th, and it can happen at any time. And the judge said that I can take care of some of those deadlines after 5 o'clock before the evening. So far I've been able to do that.
Okay. And has that in any way distracted you from this case? Do you think?
No.
And do you think that during the case you'll be able to focus clearly on the evidence and not feel like that's in the back of your mind?
I would say yes. If the trial was contained to 5 or 10 days or something like that, if it got closer to the 30th of December, then I would, I guess I would be a little bit apprehensive, if the test is closed.
Okay, thank you. Ms. Miller?
Yes.
Okay, where are you? Oh, there you are. Okay, great, thank you. Did you have a hardship that you talked about?
I did. It was regarding coverage at work. My cover, but they are now covered. They're covering competition.
So were you able to hear that, Ms. Court?
I believe so.
Okay. Was the issue of getting coverage at work something that might create a distraction for you during trial? Are you able to separate that and be able to, because being a juror is like it's a full-time job.
Absolutely.
You'd be able to do that? Okay.
Yeah.
Thank you. We're getting to the finish line, trust me. A broad question for you. Well, before I get into this question, is there anybody else who had expressed a hardship that we've already talked about? But my point is I need to talk to you again about it. Okay, tell me about it. That's... It's Miss Galindo, right?
Yes,
And you're a single parent of how many kids?
2,
All over the kids?
14 and 8.
14 and 8?
Mm-hmm.
Is that yes?
Yes,
And did you say that you were unable to find somebody to help you?
I don't have family, I'm not married. All my friends I work with because I'm here. I came basically here for work.
What times do your kids get out of school?
I have to pick up my youngest at 6, by 6.
And why do you feel like you would get public service insurance?
If the school called me, I wouldn't be able to pick up the phone or check voicemails during the jury or during the trial.
Do you think that being a single parent and having that in the back of your mind, concern for your kids, might in some way impair your ability to stay centered on what's happening here in the courtroom?
Yes, I believe so because my daughter comes home from school, high school, and she's home alone until I get home.
Okay, thank you, Dr. Candor. Is there anybody else who I haven't talked to who had previously mentioned that they may have a hardship? Mr. God, right? Okay, we'll just
the driver. I live in South Bay, and my job not paying.
You were the driver. You do the. What was your job again?
I work for Palm Train with the connection.
Okay. And you're not getting paid while you're being here.
Yes.
Okay, does that affect your desire to want to be here?
Yes,
It does. How so?
Well, the money out of my pocket and everything, and I just came off vacation. I haven't worked since the holiday for 2 days.
And is that a hardship for you financially?
Yes,
Thank you, sir. Is there anybody else, Dr. Barsky?
Yeah, I mean, I spoke the first day just about responsibilities at work and also at the hospital. So.
You're a pediatrician, right?
Yep.
Okay. Do you feel like, well, before I even ask this question, when you're a pediatrician, you're obviously focused on the kids that you're seeing, right? When they come in, I've got a little girl, I take her in, I want that pediatrician to be focused, right?
Yes.
And I take it, you seem like the kind of guy that's like that, right?
I think so.
All right, so are you able to take that same level of dedication that you have as a pediatrician and bring that positive character trait into this courtroom and be able to stay 100% focused on what's going on in this courtroom? Or is there going to be something in your mind lingering about what's going on here at the office of patients?
I mean, I spend a lot of time at work, so that's where my passion is, and I put a lot of time into a local hospital, and that's where my passion is. So there's always a part of it, me, that's thinking about that place. So.
Would your thinking about how your pediatrician practice is going in some way kind of interfered with your ability to stay focused on what's at stake in this case?
It's just a little, it's a distraction. So I have, again, I have responsibilities that can come any time of the day or night. So not having access to my phone or a text or something like that, yeah, that could impact my attention span.
Thank you, sir. Is there anybody else who I haven't spoken to this afternoon who had previously articulated a hardship?
Simone?
See, Mr. Simone?
Yes.
Okay. If you could maybe just try to speak up a little bit.
Yeah.
Okay, great. So tell me about your hardship again.
My hardship is I live in Boynton Beach, and we only have one car. My wife, she's not working, so she took care of the kids. So a few minutes ago, she called me, and she couldn't find nobody to pick up the kids at school. And I have the car. Mostly, she used the car. And I get up early in the morning, go to work, so spend the whole day at work until I get home. That's when I use the car. So it's hard for her to find somebody. So that's the hardship I have.
So there wasn't anybody to be able to pick your kids up at school?
No.
All right, and that would be a concern you have throughout the trial?
Yeah.
Thank you, sir. Is there anybody else that I haven't spoken to this afternoon who had previously identified some form of hardship? Okay, Mr. Douglas. I'm sorry. Right. When is your cruise again? I'm sorry. The 18th. Okay. All right. Other than the cruise, was there anything? Okay. All right. Thank you, sir. Anybody else I missed? Miss Lencina or China? Lencina. Miss Lencina. What did? There's the microphone. I'm sorry.
I'm starting a new job on the 15th, and I gotta be there from 8 to 5.
And what is the new job that you're starting?
It will be at the breakers.
And are you supposed to report the first day of work on the 15th?
Yes,
So would it be a hardship to you if you were not able to show up at work?
I think so.
Okay. We have to ask these questions. I'm sorry.
That's fine.
Some of them are so silly. Thank you, ma'am. Anybody else that I've missed this afternoon who may have a hardship that might interfere with your ability to be here today, stay focused on the facts, that previously talked about it, but I haven't talked to this afternoon? Anybody else? Okay. Let me move on to one other area I wanted to ask everybody about. Oh, and for the record, showing no hands to that question, that last question. This is a question for the general panel. Let me try it this way. Let me start with row one. Anybody in row one who believe that whatever a person says, and you'll see a video in this case, that is absolute and that you would be unwilling to look at the context of what is said? Is there anybody in here that's in the first row that believes that what they see and hear is 100% concrete? Okay, showing no hands. Row two. You'll see a video in this case, and there'll be words expressed in the video. Your Honor, I'm not going into it.
Oh, hold on, just approach it.
moving back to row 2 again. So the question is, you'll see a video in this case. There'll be words spoken in the video. Is there anybody in row 2 that is only going to listen to those words without looking at the entire picture and all the evidence? Okay. Are you Miss Parsons? You seem a little baffled.
Yeah, I'm not quite clear on the question at hand. So you're showing us the video, and we're not supposed to
No.
we're supposed to also listen to the other stuff and the video.
Right. Are you able to obviously to separate the two? Somebody said that right. In other words, you're gonna the video will be evidence,
Yeah.
and I can't get into what the video is.
Yeah,
I'm not going to do
no.
that. But video is going to be evidence. You're going to hear words spoken. My question is, are you the type of person that focuses only on words spoken, or are you able to consider the context of what leads up to the words spoken?
Oh, the context,
Yeah.
yes.
Are you able to do that, or will you just hear words and say, that's all I'm going to listen to?
No, I'm not, I don't wear blinders.
Right. That's probably better said than what I said. Right. So, okay. You sure?
Yes.
All right, great. Going back to row 1 and 2 then, with that clarification kindly by Ms. Parsons, anybody in row 1 and 2 might think they would have blinders on in this case once they see the video. Showing a no hands. Moving to row 3. Anybody in row 3 who thinks they would be unable to separate words spoken versus the complete context in this case? Because we live in a world of video. You know, people are filming things every day with their iPhones, and so you'll see video in this case. So row 3, anybody in row 3 thinking, I'm going to see something, whatever that person says, they're stuck to it, I can't consider anything else. Anybody in row 3? Showing a no hands. Row 4, same question. Anybody in row 4 that would do that? And how about row 5? Row 6, showing a no hands, by the way, for the record, apologize. Row 6, anybody in row 6 that's going to look at words spoken and say that's it, can't listen to anything else in this case. Anybody in row 6? Showing a no hands. Row 7, same question. Showing a no hands. And Mr. Martinez, how about you? Saying no? Okay, thank you. Your Honor, may I have just a brief moment with Mr. Rosenfeld? I think
Yes, you may.
Mm-hmm. I think we're done. Thank you for your time, Your Honor.
All right, thank you, Ms. Claypool. All right, ladies and gentlemen, what I'm going to do now is I'm going to spend some time with the lawyers, and I'm going to select the jury to hear and decide this case. I'm not real good at these estimates. I usually tell folks to be back at a certain time, and it usually takes a little bit longer than that. But I still want you back at the time I designate, because as soon as we're able to move forward, I want to get you in, get the jury seated that's actually going to hear the case, then be in a position to discharge everyone else. I'm going to ask you to be back outside of this courtroom at 3:30. I hope I'm going to be ready to bring you in at that time. I will apologize in advance if I'm not. As I said, sometimes I do not estimate correctly the period of time required to actually select the jury. We do have a large number of you, and we do have to go through a process. So 3:30, you're to come back, be ready to go outside of this courtroom. You do not have to stay on this floor during those 40 minutes. But what you do have to do is not discuss this case amongst yourselves or with anyone else. Do not do any research with respect to this case, and do not listen to or read any news accounts of the trial. I know you're sick of hearing that. Unfortunately, you're going to hear it every time we break, even if you're selected for jury service. So you're excused until 3:30. We'll see you back at 3:30. Yes, ma'am, you have a question, Miss?
It was a question
Agreed.
as far as relevance to something that I was questioned when you...
Okay, well, I'll tell you what you do, Ms. Reed. You hang around for just a minute, and I will speak to you individually.
Oh, no. can scream.
Just wait.
I was a teacher in middle school.
You can, but it's probably not good court decorum, so we'll wait just a minute. I just want to wait till everybody clears, please. Okay, and we're clear then. Ms. Reed, what did you want to tell us?
It was in reference to what was discussed yesterday at lunch. I don't know if that's relevant.
Sure. Tell us what was, you
Okay.
remember something else that was discussed at
Yes.
lunch?
When I was with the husband, when the wife was inside, he was discussing how she had fallen and the medical condition she had that caused that. And he said, well, I'll go more into it when she comes back. I don't want to talk behind her back. And then we discussed they were planning to go up to Tennessee to Knoxville.
Okay, so Mr. Malin discussed a fall that his wife had.
Correct.
And that condition and what it might have caused. Also discussing a move to Tennessee. Returning to my original question, any further discussion at all with respect to the case?
No, but you had asked me what we discussed, and I really thought about it and thought about
Well,
it.
I know, I took you by surprise.
Yeah, and then when I thought about it, I remembered.
Okay. Anything, let me see, the attorneys have any further questions? Ms. Claypool? Okay. Thank you, Ms. Reed. You're excused until 3:30.
One second. Neil gave me a defective pen.
Gave you a what? A defective pen?
Answering that today.
I've had about 3 run out of ink out here so far. So. Okay, let's talk about moving forward. Mr. Rosenfeld, I told you at the close of voir dire, if you wanted to renew motions or make motions, I would hear them, so this is a good time to do it. I'll hear those motions, I'll make appropriate rulings on those. If we proceed with jury selection, then I'll tell you how we're going to do it. I mean, I'll ask how much time you guys want to go over your notes.
Yes, Judge. I mean, I think we went through all the arguments and nauseam at this point.
Well, the horse has been around the track a couple times, but.
Well put. You got some laughs out of us.
Well, it's not. Look, I understand, and I think Mr. Claypool made this point. Sometimes you need a little levity in the middle of a trial. It's a serious matter. I understand these are serious things that you're raising, so I don't want to make light of anything that's being advocated on behalf of your client.
I would just say this, Judge. I'm going to reiterate the high-profile nature of this case. I think we should have changed venue before we even started the voir dire process. I take a look at, or I addressed the number of YouTube hits earlier. Just to give you an idea of how big of a number 554,523 is, it's gone up about 1,100 since last night. To just show you how many people are watching these videos online, that's about 30% of the population of Palm Beach County. So you have a astronomical amount of people watching this. And I'm going to reiterate that, the court erred on the side of caution. They were liberal in their approach with Mr. Goodman's trial, even when there was only 16,000 views. And they made sure Mr. Goodman got a fair and impartial jury by picking a jury from out of county and coming back to Palm Beach County. And that's a great idea. I think we'd all be amenable to doing that. Mr. Claypool and I spoke about that, and we thought that may be best remedy. Now, I mentioned earlier, Boynton Beach Police Department's videos are still up on their personal page. Information about the case is still up on their personal page. These are things that are readily available that people within this county look at. As you know, we have countless jurors who live in Boynton Beach. There's been a number of contaminating factors that we can only speculate as to that have happened during this jury process. You had an open media door. You had who knows what contamination with Mr. Malin. We still have quite a bit of concern about that. And Ms. Dippolito, through her previous experience, is very concerned about that. You had the woman in the hallway, who I think it was, I want to say, the other woman who came in the other day who discussed everyone talking about the case.
It was Ms. Lopez.
Yeah, the excitement about the case in the hallway.
Ms. Lopez.
And this is something you wouldn't have outside of this county. We checked the media market. The media market in, we had our investigator look into that. In Palm Beach County is significantly higher than in other counties. And I know it is a national case, but that is something that this court should take into consideration. You're receiving a much more local media here than you would be in Miami, Broward, Hillsborough, and we can get you the statistics. They show that, and that would absolutely guarantee a more fair and impartial jury. I mean, you're dealing with a crime of this severity, and Your Honor is well aware of the sentence she could be looking at. We should err on the side of caution. We should err on the side of ensuring that she has a fair and impartial jury. I mean, we've had jurors, you could use the word lie or not be completely forthright. I know I said, I believe a juror lied earlier. You said, well, I don't know if she lied. I don't think she was necessarily forthright with the court. That's a better way to phrase that when you would ask, hey, have you seen any media coverage whatsoever? And you were very specific in your question as to make sure everybody there appropriately responded. And then she didn't bring it up. And how many other jurors aren't bringing things up? Mr. Claypool went through local news with certain people. I sent Your Honor a 128-page document last night with every media clip that's been played from here to Fort Pierce from November 28th to December 5th. And there is no way people who watch the local news could not have seen those clips. I cited statistics earlier about, that was 120 television news programs in a 7-day span in this area. 150 local news articles in the last 30 days related to Ms. Dippolito's case, and that's in Palm Beach County. 28 local newspapers in the past 3 months with the term retrial in the headline. So if you have people here who read the local news, I just can't see how they couldn't have come across this. And the risk is too great. We can, and I know, we've all discussed this. Your Honor's done a very thorough job and has tried to ensure that she gets a fair and impartial jury. But with all the media coverage out there, it's no matter what precautions you take, no matter how careful you are, there's no guarantees. It's too big of a risk. Her liberty's on the line here. And, the case law, and I quoted it earlier, Judge, and this is not as the presumption.
Do you remember the Pauline Zile case?
Which one?
Pauline Zile. Do you remember Pauline Zile?
Brown.
Pauline Zile was trapped. Judge Rapp tried that case right here. There is an excellent discussion of the law on this subject from the 4th District Court of Appeal in the Pauline Zile case. For those who don't know what do you recall the case, Mr. Rosenfeld? Was that before you were practicing here?
I recognize the...
It may not be instantaneously recognizable. I will tell you the coverage in that case exceeded the coverage in this case. The reason is the facts were so egregious. In the Pauline Zile case, a man and a woman killed their child, a young daughter, buried the girl, and then called the police and acted as if the child was missing. And so there was like a 1-week period where law enforcement was out looking for the child. And as it turns out, the child was not missing, the child was not abducted. I believe it was the boyfriend or the man. I can't remember whether they were husband and wife, quite frankly, at this time.
They had the same last name.
Yeah, I think it was the Ziles. I think they were husband and wife. As it turns out, the husband had beaten the child and the child died. That case was tried here in Palm Beach County. It was tried by Judge Rapp here in this county. Actually, he tried Pauline Zile. One of the other judges tried the husband. And the point of all this, is the media coverage in that case was just as significant as the media coverage in this case. And the court went through an analysis to determine whether or not it was necessary to move the case. I'll skip to the bottom line, then I'll tell you the reasoning. The bottom line is that the 4th District Court of Appeal concluded that it was not necessary to transfer venue, affirmed the conviction of Pauline Zeil that was tried by Judge Rapp. And a couple of the things that it said was that the court does indeed have to consider, it's kind of a two-pronged test. You have to consider the extent of the publicity, which I have. It's been extensive. You have to consider the difficulty of jury selection, obviously, and it's been more difficult than the typical case. But the 4th DCA went on to explain, unless there's a showing of really impossibility to get a impartial jury, there is no mandate that the case be transferred. It also said, the 4th DCA said, and this is consistent with other federal cases, even going back to those cases I referred to in the 1960s, that it's not necessary, it's not even necessary that all jurors not have some knowledge of the case outside of court. The question again becomes, can they lay those things aside? And they made reference to the Rawlings case, which was out of Gainesville. You might be familiar with that case. That's the case where Mr. Rawlings was accused of and ultimately convicted of killing 6 University of Florida students. That case was tried in Alachua County, in the home county. Every single member of the venire had knowledge of the case. Florida Supreme Court, the analysis becomes, can you select impartial jurors with that pool who will set aside any preconceived notions, any conclusions, any opinions, and decide the case based on the evidence and the law, leaving it to the trial court to make that determination. Affirmed, again, the conviction of Mr. Rawlings, and also affirmed that the trial court was not required to transfer the case out of Alachua County. Now, do I have the discretion to, and could it be done? Yes, and the reason that I continue to deny your motion is that I believe I have the opportunity, we'll see in a few moments, I have the opportunity to select an impartial jury here in Palm Beach County, and that it is not required at this time to transfer the case out of Palm Beach County. I've tried to address every single thing that's come up. Your position, I understand, Ms. Rosenfeld, your position is, and if this isn't what you're saying, let me know, but I think this is what you're saying to me in all candor. What you're saying is, Judge, despite your best efforts, you're not suggesting I haven't tried, but whatever you do, it's not going to be enough. I think that's your position. Whatever I do, given the nature of the publicity, what's going on in the county, your position is it doesn't really matter. We're not criticizing what you did, Judge. What we're saying is it doesn't matter what you do. You're just not capable because it's impossible to select an impartial jury in this county. I think that's the position you're taking. Am I right?
Yes, Your Honor.
Okay, and I appreciate that position. But again, I've looked at this panel. I've gone through the process, the voir dire process, the questioning process, and I do believe we have the opportunity to seat an impartial jury, which is the constitutional mandate, an impartial jury, and that it is not necessary to transfer the case at this time out of Palm Beach County.
I have 2 questions.
Sure.
The case in front of Judge Rapp, what year was that?
I'll give you the site. I've got the case in front of me. It was 1998. The case is 710 Southern 2nd, 729. Still good law.
So let's say the case was tried in 1996, if it hit the 4th by 98?
Yes. I mean, if you're going to tell me it was before the internet, I'll concede that.
Yes. I mean, what social media has done to Dalia Dippolito is, I mean, I can't even think of an adjective to use to describe the prejudice it has had on her ability to have a fair trial. So you're saying,
but acknowledging
1996, when the internet isn't, a percent of what it is these days.
No, but that's not the point. I don't mean to cut you off, Ms. Rosen, but that's not the point.
We're not saying jurors can't know about Ms. Dippolito's case. I mean, sure, that might be impossible for jurors to have no knowledge, but our concern is that these jurors, regardless of what they said, based on things they've watched, based on how much local news there are, necessarily has heard things that they shouldn't know, whether it be the retrial, which I think is unavoidable based on the news coverage, whether it be the staged crime scene, which is unfairly prejudicial, whether it be the nonsensical poisoning allegations, which we don't know if they know about them without asking them. And there was I believe it was a Palm Beach Post article which said, a few days before jury selection, which said, poisoning allegations kept out. And how do we know whether or not these people who read the local news saw that article without asking them. And we can't ask them, so we're kind of stuck in a situation where we're assuming, they don't know this unfairly prejudicial information, and Ms. Dippolito's to suffer, and her constitutional rights are being deprived. I mean, if we didn't have the statistics we have, I wouldn't be as concerned, but they are so overwhelming, and the fact that they're that high, and the trial hasn't started yet, the fact that they're 450,000 YouTube hits, and Ms. Anthony's case had about 1 million, and that's 6 years after her case. I can't imagine how many YouTube hits there are going to be for Dalia Dippolito's case, 6, 7 years from now.
I'm not going to speculate. I'm just going to say I've gone through the legal and factual analysis, and I believe I have the opportunity, without moving the case, which is within my discretion, as long as I can seat an impartial jury. I believe that I can do that with this, or have the potential to do that with this panel, through the voir dire process that we've gone through the questioning. And so I'm going to again deny your motion. I think you've set the record. I mean, you've made the motion a dozen times. You've done everything you need to do to preserve that appellate issue. If I'm wrong, I'm wrong. But I've gone through the analysis, and that's my conclusion. So, with that said, I want to at least attempt to select a jury this time around. What I typically do, I think, Mr. Rosenfeld, you've tried a case with me before, right?
Yes, Your Honor.
I think Ms. Laurie has also, Mr. Williams. I will ask you this. Do you want to do for cause? I'm going to give you some time to look at your notes and confer before we start the process. Do you want me to take up the for cause challenges first before you guys have that conference, so you know who's off the table and who's on the table?
Yes, we don't want to discuss peremptories, so we go through the causes.
Okay, so, I mean, well, I always do the for cause first. It's a question of whether you want me to do the for cause after you put your head together or before.
Let's do the for cause first.
Okay, fair enough. Let's do that then. And let's go through this and take any for cause challenges. Typically what I will do is I will go row by row. Okay, for cause challenges on the first row, I'll just start with state, doesn't matter. Mr. Godwin? I mean, here's what I do. I think, Mr. Roosevelt, you know this. If you guys agree, I just say you guys agree or disagree.
We'd agree.
Okay, so Mr. Godwin, by agreement, I'm going to go ahead and remove Mr. Godwin for cause. I don't know whether it's cause or hardship, what you guys are stipulating.
My basis was the hardship.
Okay, well, if you stipulate, I may or may not have agreed with that if you didn't agree, but that's fine.
Hardship.
Okay. Still on the first, or anything else by the state?
No, sir.
We have
Defense.
Yes, Judge. 1-2, juror 1-1 acknowledge that juror 1. Juror 1-2 acknowledged that juror 1-1 acknowledged that juror 1-2 was asleep yesterday.
State. I've been watching him. What he does is he puts his head down like this when you're talking to other people. I don't know whether he's actually asleep or he's just putting his head down.
Oh, she affirmatively said to Your Honor, he said, "Let me know if I'm snoring." I mean, we.
Yeah, but.
I think that maybe is in a joking context of.
Well, anyway, the position of the defense is that Dr. Spire was, or Spire, right? Doctor, the dentist, was sleeping. Okay, I've been observing him since those comments were made. Anything from the state?
No, sir.
Okay, I don't think I have enough yet to remove Spire for cause. I'm going to leave him on for
And
now.
respectfully, Your Honor, that was yesterday, not today, so.
I know, but I've been observing him. Actually, you told me, I made a note of sleeping early on. You told me early on you thought maybe he was.
I told you about 1-8 and 1-9.
I've got a note that goes all the way back. You actually indicated, please watch Dr. Spire. So I've been watching him. Okay, in any event,
If you want to do a replay, it was at around 10:52 a.m. is when you dozed off today. I have the time. Want to see him sleeping?
I don't think it'll show him sleeping because they don't show the jurors. At this time, I'm denying the for cause on 1-2. Anyone else on the first row?
State, Your Honor.
Give us just a moment, Your Honor. I want to be very careful with this process.
Okay.
Do you have anything on 1-1? I'm see if there's anything in 1-1 and 1-2. Oh, yes, Judge, we move for cause juror number 1-2. Juror number 1-2 knows about this case.
Oh, on the basis of knowledge.
Yes, Judge. We don't know the extent of his knowledge. We don't know if he knows about any of the inadmissible information. We have a reasonable doubt as to whether he can be fair and impartial if he does know information that could, of any of these inadmissible prior bad acts.
Okay, State.
I'm trying to find what I have.
I have extensive notes on all this, but I want state response.
He said that he watched the news, he joked and said that he told his wife to be careful who she hires, he hadn't reached any conclusions, and he didn't want to really pay attention to what he saw on the news.
I think Mr. Williams pointed to 1-8, I was saying 1-2.
No, it's 1-8 original.
No, he was 1-8 on the original list. That's why he said 1-8. He's now 1-2 on the new list.
I'd argue it doesn't matter what he says his ultimate conclusion is going to be. If he saw information that was unfairly prejudicial, whether or not he can discount it, I mean that.
Well, okay. I'm going to deny the for-cause challenge again on 1-2. What he did say is he recalled no specifics. There were actually no questions by defense of this witness on this subject matter. He said he has no preconceived notions, no conclusions, no preconceived notions where guilt or innocence, can decide the case based on the evidence, set aside anything he may have said or heard, even though he didn't recall the specifics. So on that basis, I'm going to deny the for-cause challenge.
But that's our concern. You say, we don't question him about it. What are we going to say? Hey, juror number 1-2, did you hear about the allegations of her being poisoned?
No, but you question other potential jurors. What did you hear? And you drilled down on that. I'm just making a note. I ask all the relevant questions. Those relevant questions, I reached the conclusion this person can at this time be a fair and impartial juror. He recalls no specifics. It was nothing recent. He remembered when it first happened, nothing since then. He has no preconceived notions, no conclusions. And so I'm just noting that you didn't even ask any further follow-up questions. So, and you asked questions of others, but based on what he did say, not necessarily what you didn't ask, he's qualified at this point, so I'm denying the for-cause on 1-2. Do you have anyone else on the first row?
Yes, juror number 1-9.
1-9. Hernandez.
Yes, 1-9 dozed off during your comments and right to remain silent. Dozed off when you were talking to juror number 1-5, was sleeping for a third time during the law enforcement instruction. I think I was trying to point to Your Honor, actually, at times. He hesitated 2 times when he was questioned about law enforcement.
Well, but he explained his hesitation was he doesn't like, he said, chit-chat. So I think he also has some, he has an accent, and I'm not sure whether he feels confident immediately blurting out an answer. So I'm not really attaching much to the fact that he hesitated in response to the question, because there was careful follow-up by Mr. Claypool to that.
When he was asked about solicitation, he said, "I don't like that," very low regarding the nature of the charge. Is that the quote you had?
Well, that's like saying you don't like robbery. I mean, no one likes it. It's a question of whether they can listen to the evidence and decide whether or not the state can meet its burden.
He also said to Mr. Claypool, "I will judge her by the evidence that the state brings and that you bring," which, at least in my mind, brings a reasonable doubt as to whether he understands the burden. We have no burden to bring forth evidence. The state has the sole burden.
That's true, but at that point, Mr. Claypool kept talking about if I present evidence of law enforcement witnesses. I mean, his response to the question, I took it in context, was, yeah, consider whatever evidence you guys present. I didn't take it as a burden-shifting type comment. Because there were questions asked of him. If I show you, if I present evidence that the police department is lying or that they didn't follow protocols, so there were several questions about that. And so I think in the context, that's what he was referring to. I didn't take it as not understanding the burden of proof.
I mean, I think the fact that he was sleeping during the most important instructions in and of itself is enough, Judge. As an officer of the court, I am telling you, I have 3 instances where this gentleman is sleeping that are, fundamental constitutional rights, and if that's not a ground to strike someone or raise a reasonable doubt as their ability to be a fair and impartial juror, I don't know what is.
State.
Your Honor, this juror is literally right in front of me, and I can tell the court that I do not believe is sleeping, because I hear him jingling his keys quite a bit, actually. That's caught my attention quite a few times. But he, I think, looks down. I've seen him. For the record, he is a man of larger stature who exceeds the width of the chair and sits with his legs apart and his hands on his knees and his head looking down quite often. And I think it's the way he's positioning, the way I've interpreted it, it's the way he's positioning his body in order to maybe find comfort, or the way he's just sitting. I think most jurors don't enjoy sitting through either side questioning them, that we've been doing for hours and days and days. And I've never heard him snoring. I have never seen his head nodding down, jerking up, things that may be indicative of somebody who's dozed off and was catching themselves waking back up.
Well, that's great. My fiance doesn't snore. Does that mean she's not sleeping? This is the
Okay,
most
look.
outrageous thing I've heard in my life.
Hey, look, I haven't personally observed him sleeping, and so therefore I'm denying the motion.
I would ask
clause.
that this court watch a video of him then.
It's denied. Move on. I have to personally observe these things.
Judge, after I brought it to your attention, you still didn't look.
Mr. Rosenfeld, your objection is overruled. Move on.
Juror number 2-1, we move for cause.
State would agree for language.
2-1, okay. Ms. Sun, remove for language.
Juror number 2-3, we move for cause.
You go ahead and state your basis. I think I know where you're going with this.
She knows the case, heard news, saw police take her away. She was wearing a tennis hat, looking for someone to kill her.
This is the fake video issue, or the fake
Correct,
crime
fake
scene
crime
issue.
scene, yes.
Okay.
I agree on the hardship issue of it. I think she stated she's starting a brand new job. She works as a housekeeper, has a 1.5-year-old.
We'd also agree to hardship.
All right, well, we're just going to remove her. You guys are agreeing anyway, so we're going to remove her. We'll get to other fake crime scenes later, I'm sure. Okay, anyone else on the second row?
None from the state.
Defense on the second row.
Let's just look through our notes. Uh, 2-8 knows the case, heard someone plan to kill her husband and plan failed. Watches the West Palm Beach local news. And in light of the evidence I provided, Your Honor, in light of the local news coverage, especially in relation to the retrial in this case, we necessarily have a reasonable doubt as to her ability to be fair and impartial.
Okay, state.
I don't remember all the details on Ms. Kilmer.
I do. She did not view any videos. She, again, had no preconceived notions, no conclusions about guilt or innocence. I did not find any basis at this point, other than the fact that she did have some contact with the case at one time in terms of seeing something in the news. There's nothing else there that would justify removal of Ms. Kilmer. So I'm going to deny the for-cause challenge on 2-8.
And what is reviewing 2-5, Judge? We're going to have 1 minute.
2-5, Sherrod. Okay. That should be based on something other than knowledge, because Sherrod did not indicate knowledge. Is there an issue with 2-5?
No. Which one did you just reject? Was that 2-8?
2-8, Kilmer. Yeah, Kilmer did have previous, she was one of the ones that raised her hand, but she didn't see any videos. And I went through the litany of questions I normally go through, and I'm convinced that she can set aside anything she saw.
We move for cause on 2-10.
2-10, Parsons.
Yes, and that was the woman who came in with the note.
There's too many questions on her.
There's reasonable doubt as to her role in the board.
Okay, so the state's going to agree to Parsons. 2-10 is removed for cause. Okay, are we done with the second row? Ready to move to the third?
Yes, Your Honor.
Okay, third row?
It would move on 3-2.
We would agree.
Is that on hardship?
No, sir, it's, well, I guess hardship would exist, but mine is more focused on what she said sidebar of her previous interactions with police, having been profiled by them, as well as her family, and she has an ingrained distrust.
We would agree. We would agree for both.
You're agreeing anyway, so I'm going to remove her. I'm not sure you would have gotten there based on the questions you asked, but they're agreeing, so. If you agree, I will strike the juror. So 3-2 will be struck for cause.
Does it say have any more from the third round before we?
State done, so I can go to the defense. Defense.
Juror number 3-1, Mr. Jones, when you asked him about the conversation with Mr. Mallon, whether they discussed the case, he said, "I don't think I did." That's not, I think that's enough to establish a reasonable doubt as to.
He came back in, didn't he?
Yeah, his quote was, "I don't think I did," was his initial quote.
All right. State.
I think nothing that anybody said rose the cause on Mr. Jones.
Okay. I'm going to deny the for-cause challenge on juror 3-1. We questioned him, and I'm comfortable that he did not speak with Mr. Mallon about the case. So I'm going to deny on 3-1. Do you have additional on that third row, Mr. Rosenfeld?
Juror number 3-4.
Herrera?
For several reasons, yes, Your Honor.
I'd agree, because some of my notes,
all over the place.
it says she may have thought that she would be.
Yeah, I mean, there's no question on 3-4. 3-4 is granted.
We'd move on 3-6. One, I have a concern whether there is a hardship with no one taking care of the dogs. I know they're not children, but I don't know if that's going to affect your ability to listen.
That one's not going to work.
I just feel bad for the dogs. The bigger issue, or two other bigger issues I have, are one, the alerts from the Palm Beach Post, and two, she has watched local news, CBS. There have been a plethora, or has been a plethora of news coverage relating to the retrial in this case on both of those stations, which obviously we could not ask her about without getting into the retrial. And also she had, yeah, she actually got news alerts from the 28th through the 5th. That was in response to that question. And if Your Honor looks at the research I gave you, there have been a ridiculous amount of articles relating to the retrial on those dates. That's one basis. The second basis would be she has acquaintances in West Palm Beach Police Department. There are some of the prior bad acts the state's trying to introduce involve the West Palm Beach Police Department. We're concerned that she might know these officers. I know generally, this court reads a list of all parties involved, or the state reads a list of all parties involved. That was not done by the state in this case, but her relationship with one of the departments involved in this case does raise concern about her ability to be fair and impartial. Okay. Especially if in the middle of the trial it comes out that she knows one of the cops.
Yeah, I don't think you've gotten there on Ms. Is it Butcher? Botcher? So I'm going to deny the for-cause challenge on 3-6.
Would Your Honor be willing to question her as to which officer she knows, so we can?
She told you the name of the one. She said the rest of them are just acquaintances. They just were at the Green Market. The only one she knew, she told you. In fact, I think she said she had lunch with her. I mean, you can look in your notes, but she gave the actual name of the officer, and I'm assuming it's not an officer that's identified with the case.
I believe that it was Brigitte Larson, who, I think that's the name she said.
That first name sounds familiar to me. I don't know about the last. Okay, in any event, I'm going to deny the for-cause on 3-6. Any on the more on the...
Judge on the newsground and the...
I'm denying on both. I don't think there's any indication that she has seen anything relating to the case, and she's been asked those questions. Anything else on the third row before I move to the fourth?
Yeah, we have concerns about 3-3, hearing about the case in the past, Judge, and knowing about the case. We're also not sure if she knows about the inadmissible evidence.
Okay. Her testimony was, or what she said was, I think I remember hearing the name on TV, do not remember anything specifically. It was all in the past, nothing recently. No conclusions about guilt or innocence. Can decide the case based on the evidence. The law can set aside anything she may have read or heard and decide the case, or also, just parenthetically, no questions by either side with respect to her exposure to media coverage. So I'm going to deny the for-cause challenge on 3-3. Are we good on the third row? Are we ready to go to the fourth row?
Yes. I'm trying to see what she said about 310, said about called law enforcement.
310, Blanc.
What did she say about? Now, we can go to the fourth row.
Okay. Fourth row, state, anyone on the fourth row?
One moment.
Anyone?
Judge, I think Mrs. Chapnick, 4-3.
I think so. Ms. Chapnick. So by stipulation, both sides agree 4-3 should be removed for cause. Additional on the fourth row by state, then I'll ask the defense.
Okay, anybody for cause?
All right, defense.
I got a few here, 1 second, Judge.
Well, I do have one.
Which one?
You have one? Let's see if,
7, Ms. Shorten, she talked about, find the note. She was talking about prior interactions that she had had with the DA in New York, and
We agree.
she stated that it impacted her life.
I agree.
actually, I don't agree. 4-7, what are you talking about?
Remember when I questioned her, I had to spend like about 2 minutes with her going over, setting things aside, acting like an adult, checking things at the door. She said she had such a bad experience with the DA in New York that it just left a horrible experience with her about the prosecution.
She
You said it wouldn't affect her.
She said it had a big
At the
impact.
very end it did, but it took me several minutes to go with her, because she kept saying, I'm not sure, I think it will, I don't know if it will, and then I finally got her to commit that she wouldn't, but it was a back and forth type
To
thing.
be candid, the state asked her about being fair and impartial. She said, I don't think so.
And I actually asked, I had written down that she said the event had a big impact on her life, and it's deeply ingrained in her.
Yeah, I got that. I don't know the part about her saying, because when I hear someone say they can't be fair and impartial, my ears go up immediately. I don't know that.
My concern would be that if somebody's saying something is deeply.
No, I understand, but Mr. Rosenfeld made a statement that,
I have it on my, I have victim of Bergbat, it looks like BB.
all right, I'm going to go ahead and agree, but I'm not sure, absent agreement, I would have granted that for-cause challenge. Okay, anyone else by state?
No, you're
All right, defense.
Yes, Judge, we'd start with 4-4. 4-4 is a resident of Boynton Beach.
Mr. Singh?
Yes, Your Honor. He lived in Boynton Beach for 1 year. We have a...
Other than living in Boynton Beach, did he say anything disqualifying?
No, but our concern is based on the case law we provided you about community bias. You have people, somebody who lives in the same community as Ms. Dippolito, Mr. Dippolito, where the crime occurred. I mean, there's a huge risk for community bias there, Judge.
He said he lived there for 1 year. He had no, in terms of police allegiances, none. No head start for police, completely neutral on that subject matter.
Same notes I had.
Anything further, Mr. Rosenfeld?
We also found some bias based on a statement to Mr. Claypool about 80% good cops, 20% bad cops. That's whether he'd led some credence to police officers.
Okay.
And that, I think he explained that extremely well. And that
Yeah, he did, actually. I'm going to deny the for-cause on 4-4. I don't think there's a basis to remove him for cause. Additional fourth row.
Yes, 4-5.
Douglas?
Yes, mentioned the cruise on December 18th. And, you know, I said from the beginning, everyone said jurisdiction is going to take a day and a half, and I said it's going to take 5 days. And everyone has underestimated how long this case is going to take. I don't want any juror to feel rushed into coming to a verdict. They need to have time to deliberate. We don't know what could happen with witnesses, evidentiary issues. It makes no sense to rush a juror into coming to a verdict, Judge. You made that clear time after time.
Your Honor, if
Yes.
I may chime in a little bit just on 4 or 5. Is that if it's Mr. Douglas?
Douglas.
I believe he was in corrections. He's got a lot of friends and colleagues in law enforcement. I just think there's a potential bias in favor of law enforcement with his background.
Also a member of the, PBA, which.
Right, but I mean, he didn't indicate any bias in his questioning, and I understand your concern on the 18th, but I have a feeling that even if we were starting to run behind, there are things I can do to make sure that he's not rushed into a verdict, including working later, getting in earlier, and getting a couple of my dockets. So I'm going to deny the for-cause challenge on 4 or 5.
We can't stay past 5 anymore, Judge.
I can stay till 6, and I can start at 8. So I can, if I don't have a morning docket, I can get a lot done if I didn't have that morning docket.
And just for the bias part of it, if I could put on the record that he stated he was a member of the PBA, but he didn't even actually know that PBA stands for Police Benevolence Association. So I don't think that.
Okay, well, I've denied it anyway. I mean, the record is what the record is. So at this point, okay. Anyone else on the 4th row by defense?
Yeah, I got a few.
Just 4-7 is gone.
4-7 is gone by agreement.
One moment, Judge, as the 4-8. She made a comment.
Who are we on?
I'm sorry, juror number 4-8. I think she was questioned individually about this.
Ms. Lopez, she's the one that said that she heard someone talking outside the first day. I wonder if this is the Dippolito case. She said she had no idea what the Dippolito case was and didn't learn anything more about it based on that conversation.
Yeah, she also, when questioned individually, I think you brought her back in, she said she heard there was about the new case in Palm Beach. She said, I can't tell if it was new, old, or existing. That, to us, raises a reasonable doubt as to whether she knows about the first trial, or whether she has any thought as to whether there was a first trial.
I think we questioned her about that.
Yeah, her response is, I can't tell if it was new, old, or existing, but she's clearly questioning whether there was an old trial.
Okay, State.
She was then questioned, to my recollection, there was follow-up questioning of, well, what do you mean, what do you think has been going on? And she said, well, she didn't allude at all to, knowledge of a prior trial, knowledge of a prior conviction, and that's when then she made the comment of, what I gathered from her answers were that she didn't know whether she had just now been charged or what had been going on.
All right, I'm denying the for-cause challenge on 4-8,
If I
Ms.
can
Lopez.
respond, even the state's response lends to a reasonable doubt. The state just said, from what I gather, so even they have some uncertainty based on that.
Okay, I'm denying the for-cause on 4-8, Ms. Lopez. Additional on the 4th row by defense.
I got 410.
Ms. Reed?
Yeah, 410 did not disclose, and Your Honor asked anybody see anything on the news whatsoever about this case, and you were very direct in your question. She didn't say anything, and today when she was individually questioned, she said, I saw TV. Let's see if I can find her exact quote.
Said she saw a headline.
Yeah, and then she saw.
Actually, she didn't hear it. She didn't see it. She heard it, I think, and then turned off the television.
She saw it on the news and then turned it off.
And then didn't listen to she didn't even look at the TV all weekend, I think, is her testimony.
And I guess that's my concern, Judge. You would ask if anybody had seen anything, even inadvertently, and she said no, and then later on she comes in here and says yes. That shows a level of dishonesty with this court. She did see something. Everything was about retrial this weekend. We have concerns that her knowing about that would deprive Ms. Dippolito of a fair trial. At the very least, it creates a reasonable doubt, her dishonesty with this court, and her having seen some headlines.
I'm sorry.
We might have additional issues. That's the one. That's the one. Yeah, then when you asked her about the mail-in, she said, "I do not recall," was her first answer.
I'm sorry about the what? I missed it.
Her conversation with Mr. Mailin, her first
Oh, okay.
her initial response, she hesitated, Your Honor said. I believe with her you said you're hesitating. I think it was with her. She said, not that I recall, then I do not recall, then she said anything is possible. So that raises a reasonable doubt as to whether they discussed the case.
State?
Judge, in my notes I have from the first day that she said she did indicate knowledge. She said that she had seen it on TV. It was years ago. She hasn't really thought about it, hasn't reached any conclusions. When questioned, she said she didn't hear anything in the hallway. As far as her conversations with Mr. Malin, I think that she
Well, let me, okay, I don't mean to cut you off, but, well, go ahead, make your record. I don't want to cut you.
I think if she was trying to hide something, she would have kept coming back to the court and going, oh, once I thought about it more, I thought of this. I just think this wasn't something that people really thought. I mean,
Look, I don't think Ms. Reed was being dishonest. I'm gonna grant the for cause challenge, but I want to make sure I'm clear on why. I think there are just a number of circumstances with Ms. Reed which I have to take into account. I don't think she was purposely dishonest with me when she didn't disclose. But she did see the video originally, although she didn't recall any of the videos. She gave all the right answers. She did go to lunch with Ms. Malin. I just think based on kind of a totality of the circumstances that Ms. Reed, although I think she probably is fine, I think that there's a reasonable doubt there for a number of, because of the, basically all of those factors coming together. So I'm going to let Ms. Reed go. Okay, anything else on the fourth row?
No, Your Honor.
All right, on the fifth row. State?
None, Judge.
Fifth row's defense.
Yeah, I think we'd start with 5-1. 5-1 has lived in Boynton Beach for the past 6 years. I think that lends itself to the possibility of community bias. We're dealing with, like, as we've said a million times.
Other than his residency, did he say anything that was disqualifying?
No, Judge, but, community bias isn't something you can raise through, or you're going to get at through, jury selection. I mean, community bias is, a subconscious problem that people are going to have trying to reach a certain verdict. I mean, there's empirical data on it. I provided you with that in the motion. United States Supreme Court's addressed it. And this is the perfect example of it. A gentleman who's lived in...
I mean, all we have is he lived in Boynton Beach for 6 years.
And he did state that he lives in unincorporated Palm Beach.
Yeah, and PBSO is his law enforcement agency.
Close to where he's not monitored by the Boynton Beach
Yeah,
Police Department.
PBSO has got his district. It's not even Boynton Beach Police.
He did make a comment, too, that he respects the police, the defense, the state, the judge. In general, he has no interactions with police. He has no biases, and he doesn't think the state should get a head start.
Okay, I'm denying the for cause on 5-1, Mr. Shaw. Additional fifth row by defense.
I did find Mr. Williams pointed out 510.
Hardship.
The hardship, the concern that would he be paying attention to what's going on?
We'd agree with that. We haven't done as hardship.
Yeah, it's close, but I'll let him go. Because I asked him the same thing, and he said he was fine, so. But by agreement, I'll let 510 go.
Juror number 5-5.
Prince?
Yes, Miss Prince has lived in Boynton Beach for most of her childhood until now. There cannot be a greater example of community bias than 5-5.
I thought she said she wasn't all that thrilled with it either, wasn't
But
she?
if she doesn't like it, doesn't mean she's not going to have community bias when she comes home and is afraid of her neighbors.
Do you have anything other anything else disqualifying other than that she
Empirical
resides.
data showing that this.
I got that, Mr. Rosenfeld.
I thought it was 5'6" that lived.
She grew up.
Oh.
5'5" grew up in Boynton Beach. I mean, anything other than the fact that she lived there.
Yes, our second reason would be, I believe in response to Mr. Claypool's question about what news she watches from the 28th to the 5th, she does watch local news. And going through the exhibits we gave, Your Honor, there's been a ridiculous amount of news coverage on the retrial in this case, and that's not something we can question the jurors about. We have a reasonable doubt as to her ability to be fair and impartial based on that.
Okay, I've got nothing disqualifying with respect to 5'5". I'm going to deny the for-cause challenge on Ms. Prince. Additional fifth row defense.
You already got Yes, juror number 5'6".
Logan?
Saw the videos and saw Ms. Dippolito in courtroom.
Okay, state.
I have that she saw the news, no conclusions, hasn't really followed it or paid attention to it. She hadn't seen any video clips. She said that she, maybe saw something when she was cooking. And what was the other part of your?
Saw her in the courtroom?
She, I think, meant that she recognized the face, but that was it.
She the one that mentioned it was within the last year that she saw her in the courtroom?
Yeah, hang on just a minute.
She's the one that asked if anybody recognizes someone she recognized the defendant.
Yeah, I mean, she didn't see any of the videos. Again, no preconceived notion, no conclusions, no problem setting aside anything she did see, decide the case based on the evidence, no conclusions with regard to guilt or innocence. Anything further from either side?
I think seeing her in the courtroom is incredibly concerning. I think she was also arrested by Boynton Beach Police Department or PBSO. She wasn't sure.
But she was asked whether she reached any conclusions based on that. She said no. She just saw the courtroom proceedings. It wasn't clear which courtroom proceedings, I'll give you that. I'm going to deny the for-cause on 5'6". I don't have enough on Ms. Logan. Anyone else on the fifth row before we go to the sixth row?
Yeah, at 5'9", I'm just trying to find my reasons.
Kobe, Dr. Kobe. She didn't express knowledge of the case, so it must be something else.
No, she said, in relation to her questioning, in regard to law enforcement is a noble profession. She hopes they have more integrity in light of their profession. And because of their oath, she wants to think they're telling the truth, which to us leads us to believe she may find the police officer to be more believable than a civilian.
Now, here's what she said. No more favorable opinion of law enforcement. She respects the profession. She would like to believe they're truthful, but that's not enough. That she never said that she would give them any additional weight or credibility simply by virtue of the fact they're a member of law enforcement, but just merely expressing a hope that they would have integrity. She also went on to say, but she would listen to the evidence. And so there's no basis to strike her.
I have the quote, because of the oath, she wants to think they're telling the truth. I want to believe in my mind they're telling the truth.
Would hope they have integrity. Would listen to the evidence, would like to believe that they are truthful. Would like to believe, and expressed would like to believe, but there's nothing about that that would suggest that she would automatically conclude that they are indeed being truthful.
I'd request to read back on that. I think we have different notes on that.
I'm not going to read it, but I'm going to go from my notes, and I actually made a note when this whole conversation was occurring that based on what I'd heard, that's not enough to challenge her for cause, so I'm going to deny the for cause on 5'9". Anyone else on the 5th row before we move to the 6th row? 6th row, State.
6th floor, Miss Graham. She said that she would hold the police to,
I don't think you're going to get an objection from defense on that, but let me find out. Graham, 6'4".
What's the basis?
She said that
she would hold police more responsible than other.
If you care, she also saw the fake video.
Yeah, well,
6'4" is gone for cause by agreement. Okay, State, anyone else before I go to the defense on the 6th row? No. Okay. 6th row, go ahead, Mr. Rosenfeld.
Oh, yeah, here, juror number 6'3".
Branson,
Yes,
prior knowledge, is that your basis?
correct. The statement she made, and I saw some news footage, and the way she described it sounded exactly like the staged crime scene.
She said she saw the stage crime.
Yeah.
She saw the fake video.
Yes, Your Honor.
I call it fake video. I guess it's stage crime scene. Different notes, but it means the same thing.
Yes, Your Honor.
Okay, State.
I have that she saw news previously when it first broke in the news, nothing recently. She saw the video and a blurb. She does not recognize the defendant, no conclusions, opinions, or notions. She said that she had curiosity, but no real emotion towards it.
Okay. She said all the right things in a conclusory fashion. We've been having this discussion almost for the entire jury selection. And right now, presumptively by agreement, that video is out. And I am concerned about that video. I'm striking the juror 6'3" for cause. Okay, any more on the 6th row by defense?
Yes, 6'6" has lived in Boynton Beach for 4 years, respects what law enforcement does. That necessarily concerns me for 2 reasons. 1, community bias. 2, extreme community bias when you have someone who's clearly concerned about law enforcement in that community, and law enforcement's going to be the ones whose credibility we're going to spend a week attacking.
Again, anything other than residents and your theory of community bias? Any other disqualifying statements that she made?
No, just her inability to be fair and impartial in light of her views of law enforcement within the same community as to where this happened, and
Okay.
community bias.
I'll deny the for cause on Ms. Whittem. I don't think we have enough to remove her for cause. Additional 6th row.
Yeah, I believe 6'8" saw the staged crime scene. She knows Ms. Dippolito in the case. She knows stuff she saw or read when the case happened.
No, 6'8" did not see the crime scene. She saw no video.
Oh, that was 6. I'm looking at the wrong note. I'm sorry.
You may be skipping to the next row. You got people in the next row, but not.
6'8" saw the arrest.
Yeah, she did not see the.
Not the crime scene, the arrest, which is part of that whole series of events, Judge. I don't know if you've seen all of it, but that ties in with the staged crime scene. I think that is sufficient to rise to the level of a reasonable doubt. And then when you asked her about her ability to be fair and impartial, her initial response was, "I think so." And then when you questioned her again, she said, "I think I can be fair and impartial. I think I can be fair." And Your Honor is to rely, the case law is clear, on her initial response, not her rehabilitation in response to a leading question by Your Honor.
Depends on the question.
Well, you initially had asked,
No, you're making a blanket statement. I'm saying it depends on the question, whether I'm supposed to.
well, her initial question was response into her ability to be fair and impartial was, I think so, and then you said, oh, we don't like terms like think.
Right, it's ambiguous.
Yeah, and then you asked her again, can you be fair and impartial? And in response to that leading question, she said, I think it can be fair.
Okay, State, anything further on Blanca?
Nothing to add, Judge.
Okay, I'm going to deny the for cause on
Then
Blanca.
regard to both the fair and impartial and the arrest scene?
Yes, I don't, she didn't see the video, and she responded to the questions that she can be, no preconceived notions, no conclusions, can set aside anything she may have seen, decide the case based on the evidence in the law. So I'm going to deny it on 6-8.
Are you saying she didn't see the arrest video? I'm confused.
Correct. No, she saw the arrest, she didn't see the video of she didn't see the fake crime scene, and my note is she didn't see the video.
And they're all played one and the same, the stage crime scene, and then you have the arrest. You have her being walked to the car.
I don't have her seeing that video either. There's no video.
Have we all ever seen the arrest?
Let me ask Mr. Williams, do you ever see the arrest?
There's a perp walk video.
The what?
It's basically like a perp walk.
Right.
See that, 6-8?
Oh, I'm sorry.
6-8.
Hold on, she originally was 4-8. I have that she saw years ago, not recent, arrest, no conclusions.
Yeah, the arrest, that's what I'm talking about.
Didn't hit close to home.
Yes.
She saw the arrest, she didn't see the fake crime scene.
Right.
I just want to clarify one thing with my client.
That's fine.
Yeah, Judge, the news shows those all in one, so just because she didn't specify, it's like a continuous thing, that she saw the stage crime scene part, I think it's a pretty clear inference that she saw the subsequent perp walk.
So-called fake crime scene?
Staged, fake.
Stage, whatever you want to call it. Whatever. Do you agree that those two are interlocking? I know she didn't say specifically she saw.
Totally different times. The stage crime scene is at her home, and the arrest videos, there's a video of what I'm calling a perp walk, where she's being taken out of the Point Beach Police Department, and there's media all over the place, and they're in her face saying, Ms. Dippolito, do you have anything to say? And she's handcuffed and being put into the car. I don't have personal knowledge, I can't represent to the court whether they've been played together on the news or not, but that's, I believe, the video that she was discussing.
I've got a bit of a concern about that, if that's, because I'm going to grant the for cause on 5-8, if they're interlocking.
That's 6-8?
I'm sorry, 6-8, did I say 5-8? That alone might not have been enough, but there was some question with respect to the ambiguity of the issue, so if I take those two together, it gives me a reasonable doubt. We ready to go to the 7th row?
They were up to the 7th, Judge.
Okay, State.
No calls, Your Honor.
We'll start with 7-1, knows Ms. Dippolito in the case, read the news. I think she said, hasn't drawn any conclusions, then possibly reached an opinion. Then based on TV and cop show, so she's seen the cop show.
It's a 8.
Potential for this to be true, is the line I have here.
Let me hear from the State.
Saw original broadcast.
He said that he saw the news, old news, that he hadn't reached any conclusions or opinion. He did see cops. From what he saw, can be true, but then when questioned further, he had no conclusions or opinions as to her guilt, and he said that he could be fair and impartial.
He gave all the right answers in terms of being fair and impartial, has not tracked the case. I am concerned, well, I know he did, because I've got notes on it. He saw the cops video. I think that's disqualifying, frankly, at this point. I'm going to grant the for cause challenge on 7-1. Okay, additional for cause challenges, 7th row.
Yes, 7-2, saw the stage crime scene. Heard on TV that case was back. I think that in and of itself is disqualifying.
Okay, State.
I don't have notes that she saw that it was back. My notes on her are that she saw the news in 2009, not recently, no conclusions, opinions, saw the arrest, saw the crime scene video, and she only heard that it was jury selection that was happening in the case.
She saw the faked murder scene also.
Yes, sir.
I'm granting the for cause on 7-2. She did give all the right answers to my questions, but she viewed that video, which I don't think is going to come in evidence by agreement. Okay, next, defense.
7-3 saw staged crime scene 2 to 3 times. She read the post on Tuesday online. She said again later she saw the staged crime scene. Read the post, may have read something, and Your Honor knows all the articles that are in the post. You have them regarding the retrial. She just saw news coverage when it happened.
I think it's Kennedy, right?
Yes.
He's our other lawyer, isn't he?
Yes.
Okay, State.
I do have that he saw the stage video, but he doesn't recall the defendant being in the video.
Yeah, he said he saw it a couple of times, so I'm going to grant the for cause challenge on 7-3. Any further?
Oh, yeah.
Neil, you just want to check on my jurors, make sure they're not revolting out there? They don't want to hear me say be patient, but that's what you're going to have to tell them.
I'll let them run free for another half hour.
Not really. Neil, that's not a bad idea. I don't need them. Just tell them where it's taking longer than we anticipated. If they want to go downstairs, get a cup of coffee, as long as they don't discuss the case or violate any of my rules, I can get them back here at 4:30. Yeah.
You know what, Judge, 7-4, and this is an interesting point we should have brought up about all people who saw the arrest. 7-4 saw the arrest, and that is, like I said, I have concerns as to whether that's separate and how it's been played throughout the media from the staged crime scene, but when we're dealing with the arrest, one, I don't see any relevance in that being played. I think it's unfairly prejudicial to be played at the trial. You have a woman being dragged into a car, flooded with cameras all over her face, which is just going to show the unnecessary media attention.
I'm not sure what you're objecting to now. You're objecting to something you think they're going to put in evidence, or you're just saying it's not going to come into evidence?
7-4, having seen the arrest, and I didn't think about this earlier when I addressed previous people who had seen the arrest tape, but I think the arrest tape is necessarily unfairly prejudicial. It's irrelevant and unfairly prejudicial. You're watching Ms. Dippolito dragged into the back of a car with, 20 reporters with cameras in her face questioning her, the police doing nothing to really push them back. The state, that cannot come into evidence. We're actually going to move and eliminate and keep that out for its unfair prejudice. I think anybody who has seen the arrest, there's one or two you may have denied, need to be excluded and struck.
Okay, State.
They would only seek to admit it in rebuttal, based on if she testified, what she would say, based on things she states in the video of not having anything to do with the crime.
Okay. On 7-4, I'm denying the for-cause challenge. She said she saw it in the news far in the past, nothing recent, hasn't followed, no preconceived notions, no conclusions, opinions, preconceived notions of guilt or innocence, can set aside anything she's seen or heard and decide the case based on the evidence. And again, just parenthetically, there are really no questions by either side of her with respect to anything further on that issue. So 7-4, I'm denying the for-cause challenge.
We'd also add to that the community bias from living in Boynton Beach for 25 years, which is the United States Supreme Court's concern.
Okay. It's denied on that basis also.
And we're going to move and eliminate to keep out the arrest video at this time?
I'm not getting into motions and limiting right now. I'm picking a jury, okay? So
I understand that, but for purposes of picking this jury, I think...
I'm not getting into it at this time, Mr. Rosenfeld.
All right,
7.6, 7.5 are left, 7.8, 7.9, and 7.10. Any additional for-cause challenges?
We're looking at our notes. Seven five, we moved to strike based on
Miller? Okay.
community bias. Miss Miller has lived in Boynton Beach for 6 to 7 months.
Other than her residency, any other disqualifying statements?
No, Your Honor.
Okay, it's denied on 7.5 Miller. Any additional defense, seventh row?
7.6, she knows the case through the news. She thinks she read something, then later on she said she saw the staged crime scene.
I don't think so. No, she did not.
I bet she saw it on the news in the past.
Oh,
She
she
hadn't.
She saw the news in the past, nothing recent, read something, not on TV. In fact, she said she didn't see anything on TV. It was not caught up with the case, no conclusions, no opinions, no preconceived notions. No conclusions, opinions, preconceived notions concerning guilt, consider any aside anything she's read in the past. Remember, she remembered the basic, story theme that I read her. Did not see anything on TV, no conclusions, or guilt or innocence.
My colleagues have advised me that I saw, I guess I could be wrong, they said that she knew of the staged crime scene.
No, I went back. No, she did not testify to that.
Newspaper. We all have staged crime scene in our notes. I don't think we're.
Well, she specifically said she didn't see anything on TV.
No, she knew of from the newspaper. She knew of the staged crime.
What she said was she knew that there was a wife accused of attempting to hire a hitman, and it was a sting. That's what she said she knew.
We had more than that, Judge. We had that she knew of the staged crime scene, and my colleagues are saying it was from the newspaper. They're correcting me, it was not from television. And in light of the fact that my motion to eliminate was any reference to or video of the staged crime scene, we say that raises a reasonable doubt. That's one basis.
Okay, what's your other basis?
She described this as, in terms of wanting to be on the jury, she said this case was interesting, amazing, and fantastical, which goes to
No, she didn't want to be on the jury. The exact opposite. She did say she was asked what did she think about it when she saw this, and she said it was kind of fantastical. Those were her words. And actually, there was a question about when you were describing it about some hesitation. She says because being on a jury would be a hardship. I'm a teacher. But then she went on to say absolutely not, that nothing would affect her, and she just was trying to be honest, but she really didn't want to be on the jury.
And if that's the case, Judge, I still have, in my notes, I have saw staged crime scene. My colleagues have, she knows about the staged crime scene from the newspaper. Either way, both were excluded in the motion and eliminated for that reason. I have a reasonable doubt as to her ability to be fair and impartial.
Okay, I'm going to deny the for cause on 7.6, Ms. Dalby. Additional for causes, seventh row by defense.
7.8.
More?
Yes. Let's see. First of all, there's a number. She moved to Boynton Beach in 2013.
It's a he, Mr. Moore. You on Moore, or who are you with?
I'm on 7.8.
7.8 is Mr. Moore.
Yes, Mr. Moore. What did I say, miss?
Yeah, Mr. Moore is the fellow who's hard of hearing.
Yes. Secondly, he said that the police would have a 5-yard head dash because of the nature of them being police officers. In response to Mr. Claypool's question, and that in and of itself shows an inability to be fair and impartial.
State.
My notes as to him is that he said when in regards to law enforcement, he was ambivalent. He said it's a necessary function, it's a difficult job. He said they're ahead because they see a lot more than the normal person, which my interpretation, I think my argument is that it's experience and training, not that it's solely.
Yeah, but there was a question by Mr. Claypool where he said, he used his race analogy. about the 100-yard dash, they're going to be ahead, they're going to be ahead based on, I'll find the exact quote, because I've got notes on it. Based on the fact that they're a member of law enforcement. In other words, in considering credibility. I mean, he did later say he was ambivalent. He said all the things you're saying, Ms. Laurie, but before he said that, he said some things that caused me some concern to look at from a cause challenge point of view.
I wrote that he said that they were, in answering whether they were ahead in that dash, was that they were ahead because they see a lot more than the normal person.
This is surely enough to raise it.
Well, you're correct, Ms. White. He said, I got my notes. Get a head start in the dash. He did go on to say they see a lot more, but I think the necessary implication of that is enough to raise a reasonable doubt. So I'm going to grant the for cause on 7-8. Seven, 8, Mr. Moore. Any additional for-cause challenges?
7-9.
That's really a hardship issue, isn't it?
Yes. Well, hardship is the first concern, if you want to agree on that.
I'd agree on the hardship.
If you want to agree on it, I will. Okay, we only have 7-10 left on the 7th row, and we've got 8-1 on Mr. Martinez hanging out there by himself. Any additional for-cause challenges?
Not on 7-10. Oh, we do, sir. We move to strike juror number 710. 710 responded to Mr. Claypool's question that 95% of cops are good, 5% of cops are bad, that deals with a reasonable doubt as to whether they can be fair and impartial and would give more credibility to police officers.
Okay, I don't think that's disqualifying. I'm going to deny the for-cause challenge on 710. I think later on he also said officers could be part of that bad 5% when there was follow-up questions from Mr. Claypool on that.
I think I just raised one more. If you could look at your notes for 4-8 real quick, Judge.
4-8?
Yeah, I think I left one thing out.
On what?
I believe...
Because I've got notes all over. I mean, I did it in order of the questioning, so what are you looking for specifically?
I believe when discussing the case and what you heard, said everything's been, or the case has been circulating. I don't know if you have that written down anywhere.
Yeah, well, it was part of her description of the buzz out inside of the courtroom the first day. So she may have used the word circulating in terms of people, is this a Dippolito case, etc. So yeah, so what is your additional concern based on that word as opposed to the buzz outside?
I think aside from, the countless reasons I raised before about, this being a new case in Palm Beach, that goes to people wanting to get on this jury, wanting to be involved in a high-profile case, people having previous knowledge of this case, in light of everyone talking about the case in the hallway prior to coming in.
Okay, I don't think there's anything additional to challenge 4-8 on, so I'm going to deny. If that's a renewed for cause, I'm denying.
I just saw that note.
Okay, I'm going to deny it. Anything left to challenge for cause? 8-1, Mr. Martinez. Interesting fellow.
Yes, I guess what concerns me the most, one of his first comments was, I'm pro-police. And the obvious inference, no matter what answers he gives after that, and he can rehabilitate himself, the state can rehabilitate him, Your Honor can try and rehabilitate him, but one of his initial comments being, I'm pro-police, is that he would give more deference to police officers. Secondly, he did see the staged crime scene.
No.
Okay, State?
I don't believe that he did. He actually said he was deployed.
Yeah, he was deployed, but he said he saw it. He actually described it. He did see it. Yeah, he said he was deployed. 2009, he was deployed in Iraq. Saw something on the news. First, he was kind of a little ambiguous. He said might have heard something, but not sure. Then he went on to describe a video. It was a fake crime scene. when he was asked the 3 questions I was asking, he did ultimately answer the question correctly, but there was some ambiguity when I first asked any conclusions, opinions, preconceived notions were guilty. He says, no, I don't think so. I think there's enough there to raise a reasonable doubt on Mr. Martinez. I'm going to grant the for cause on Martinez. Okay, I have not done a count to see how many we have left. Do we have enough left? We have enough left to select a jury then.
And if we could, I guess before getting into record, to see if we missed any for cause challenges, Judge?
Well, what I'm going to do is I'm going to step off. You guys can talk. When I come back out, if you think you missed a for cause, I'll hear it. But then I want to start selecting the jury.
Can we go to the jury room?
Yes. Well, I'm going to ask State to go to the jury room as opposed to you. You know how I handle jury selection, right, Ms. Rosenfeld? Put 6 in the box, go back and forth. We've done this before, correct? Miss Lori, you know, right?
Yes, sir.
Okay, so I don't need to go through that description for you.
You put 6 in the box.
I don't mean literally in the box. I call out 6 names. I'll just so there's no there's no confusion when I come back out. When I say I put 6 in the box, I call out the first 6. That's your presumptive jury, your first 6. Then I ask the State, with this presumptive jury, any peremptories you wish to exercise at this time. They say yes or no. Then I flip to the defense. What I try to do is flip back and forth so each side goes first in an alternating basis. You basically each time get 2 bites at the apple, because I ask you first whether or not there's any peremptories you want to exercise with these 6 in the box. If you pass, when I come back to you and I'm asking for back strikes, I'll say, do you wish to exercise any back strikes? Everyone here knows that you have an absolute legal right to back strike up until the time the jury's sworn. I'm just asking you to, out of consideration, to do it then so we know, because if you bring them in and we start back striking when they get on the panel, it just creates confusion going back and making sure we undo what we've done. So you basically, you get 2 bites of the apple as we go through. I ask you to exercise your back strikes. You can exercise them later, but at some point I say, do we have a jury? And, at that point, if you got a back strike, please, as a matter of courtesy, let me know.
After jury selection, would we start the trial, or would you start tomorrow?
I think we're going to start tomorrow at this point. I mean,
I'm asking for tomorrow, so that.
Yeah, it's quarter after 4 at this point. I'm hoping to get these folks in here and out of here before too much longer.
Thanks, Judge.
But I don't think there's any way I'm going to be able to start any substantive part of the case tonight. How long are the parties requesting to consult? Because I want to move through this as quickly as possible. Talk to each other before.
We need 5 minutes.
Yeah, 5 minutes.
We're on the same page.
Defense, how long do you need? All right, 10 sounds fine. Well, I'll give you guys 10 minutes. I'll come back out. If you thought you missed a for cause, let me know, and we'll go from there.
I'm just gonna leave it there because we're not good doing anything. I'm moving on.